Welcome to part 2 of I got an office action. What am I supposed to do with it? In the last video, we talked about substantive office action refusals and how to respond to them. Now we're going to talk about procedural office actions. These office actions are actually a little bit easier to respond to than substantive. There are many different kinds of procedural office actions that you can get, but there are two that are really common. The first most common is a disclaimer requirement, and the second most common type of procedural office action is going to be a specimen refusal. If you are doing your own trademark and you've received a disclaimer requirement, that means that there are certain parts to your mark that are not registrable. For example, my law firm is called Trestle Law. I can't claim exclusive rights to the word law because other law firms need to be able to use the word law. So I would issue what's known as a disclaimer saying that I don't claim exclusive rights to the word law in my trademark and that I am not removing it from the mark. I'm just saying it's not exclusively mine. These are very easy to overcome, and you can often do these yourself by reaching out to the examining attorney that's assigned to your case and say, hi, I would like to go ahead and acquiesce to the disclaimer via examiner's amendment. You don't have to go into the USPTO website. You don't have to do anything. You can just email the examining attorney and say, hey, can we take care of this via an examiner's amendment? And they do it automatically on their side of things, and then the mark proceeds forward. Now, if you have other issues with the trademark, so there's like a compounded office action, so you have like a substantive refusal and a disclaimer requirement, you're not going to be able to resolve everything with just an examiner's amendment. But if you only have a disclaimer requirement, you can very easily resolve that on your own. The other most common type of procedural refusal is going to be a specimen refusal. Specimens are submitted when you show that you are using the mark in commerce. So you submit, screenshots or pictures of the product with the label on it. Those are going to be your specimen. Oftentimes, if you are getting a specimen refusal, it usually means that there's something wrong with what you've submitted. Either the mark doesn't match what's on the specimen, it doesn't look the same, or there maybe is they can't see the specimen, but they will explain in the office action exactly why they are rejecting the specimen and what you can do to overcome that. While you can do these on your own, they are a little bit harder to do than, let's say, a disclaimer requirement via examiner's amendment, because you do have to go into the application, go into the website, fill it out, submit something new, make sure that it conforms with what they're asking for. So it can be a little bit more confusing and a little bit more difficult without attorney help. Again, we have a free call and a paid call that will walk you through all of this and help you decide what you need to do in the next steps. Have a great day, and I hope that this helped.